All right, Jello again. This is Ben Hitchcock crosstalk with you in my sub-zero basement here. I've got Debbie Keither, I hope, on the other line. And seemingly we're rocking and rolling. We have, just for the setup, we've got a series of emails from Andrea Olmanson's boss, ultimately and really from Andrea Olmanson, that is the attorney who called the police on yours truly for supposedly disorderly conduct, or you could say me raising an issue of ethics with her. Um, and so this really the fallout from me daring to raise these issues, I would say, about the conflict. There's a couple of conflicts, so let's go over them. Number one, there's conflict between one of the decision makers in the Stolar case is Amy Petchacek, who is now the secretary of the Department of Workforce Development. In other words, the boss of the judge. Um, we just found out that the judge's former boss is Carrie Byers' new supervisor. Just in case you thought things weren't, everything wasn't connected. We'll get more into that in a minute. So this is an email string here from Andrea Olmanson ultimately to Eric DeFort, who is the ALJ on the Teresa Folaron case. And that's the video that we put out just now about the contract between the ALJs, the DWD, and the new DHA. And so,
Oh, I'm sorry. I thought you were taking a breath there. But I do want to say something just for context, which is helpful for people who are learning about building like timelines and so forth, is that the incident that this is all kind of built around is the Stolar hearing, which was an event that happened that generated police calls and all kinds of different differential treatment. And so when we go back and we build what happened, we look at open records requests, which is what we're going to do today, or public records requests, and we build out what happened prior to the event, what happened during the event, and then what communications occurred after the event. And I just give that little tip to people that are really trying to exercise the power of public records, because that's what we're doing here. Is we are now dissecting everything that happens in and around that event. So I appreciate you letting me jump in and say that, because I love looking, we look at the date of this and we know this is right when this stuff is happening.
oh,
Okay,
and
this is right when the hearing is ongoing, like
so,
it's in
right, and
day 2 or 3.
you better believe that. And the only other piece of information I'm going to give you right now and we're going to go because this is really a public records video discussion here, is that Mr. DeFort, the ultimate person that this is going to, the hearing examiner for Teresa Folaron's case, is not even officially the hearing examiner. The contract hasn't even been signed yet, but yet he knows that he is going to take over this case. Okay.
Yes,
And not
and
only
he
that, the ERD knows to communicate with them. Sorry, keep going.
and he knows that this is the ERD's solution to their inability to remain unbiased,
Right.
is to enact this set of bias in another setting, and to this is the continuation of it. So now we can jump in, I think, a little bit more.
Good. And part of I think we need to talk about here is the way that this contract is being set. What's going on is the ERD has a Calvin Furman problem. And by that, I mean that Calvin Furman is either a witness on certain Milwaukee Public Schools cases that are before the ERD, and therefore all of the judges at the ERD have recused themselves. Okay, so part of what they're trying to do then is to have this contract to then put this over to this other division that's supposedly separate so that they can have a new fair hearing. Because guess what? The parties are entitled to a fair hearing. Okay. The other issue that this is going to break up is there is going to be a direct line from the Stolar case to the Folaron case. And that's something that time and time again, the DWD, the DOC, everybody at the state says it not only isn't happening, it's impossible for it to happen. And this is, we're going to have the direct evidence here of this going straight from Andrea Olmanson right up to this other, to prejudice. It basically, it's an essay on Ben, BHC is a piece of junk, and we've got
Yeah.
that. Ben is a jerk because we've gotten that theme a few times, which
Yes, and we have that
more power to
before.
them, right?
Yeah.
If anybody wants to say that I'm a jerk, go by all means, knock yourself out. I think the point is here is that the problem is it's going from the Department of Corrections through the Department of Workforce Development to this other agency, to the hearing examiner who's going to hear this case. So that there's
Right.
no chance for it to be unbiased. That's even if there wasn't this contract, there's an explicit conversation, and let's just get into it. Okay. So this is from Matthew Foley, is the first one that we've got here, and he is Andrea Olmanson's boss. Okay. Mary Kay Sergo is like the number 3 at the Department of Corrections, and Jared Hoy is the number 1. I'm not sure who this Melissa Roberts person is. He says, Secretary Hoy, this morning at the Stolar hearing at DWD, it's my initial understanding that before going on the record for day 3, Attorney Cross began yelling at Michelle and Andrea about them lying about former Secretary Carr's involvement and the underlying case history, to the point that Andrea ended up calling 911 to report Attorney Cross for disorderly conduct. So let's take that apart as we will, because I think it's pretty significant here. Um, we the first thing that I can say is, had I not pressed the record button so many times here, and we're going to show you through many more other public records, that the lies that they were telling about me behind the scenes would have very likely stuck. And
Oh, right. Because look at the way they have selectively categorized you as yelling. Okay, I'd like them to identify any portion of anything where I there was yelling involved. Also, where did you call somebody? Saying somebody's disingenuous or providing misrepresentation is part of the work that you do as an advocate for your clients. So that just comes in factually because that's what the facts indicate. Um, and then the disorderly conduct piece is ironic because that's the language that they're pulling through as the thread, disorderly. And you can see that or recall back to Ulmanson's insurance to tie that language in by she saying, well, I know the elements of what that is legally, so you can just take my word for it. I've checkboxed all the elements, and yes, it's disorderly, even though the recording shows no such thing.
well,
So
and
right, they're
right.
just
And
weaving this
even
in
though
all the way
the
through.
governor's office is actively talking with the police, and as if, what they say actually matters, and what's going on behind the scenes isn't actually what's determining that. So if we accept Debbie's translation there, I think we could get to the morning at the Stolar hearing at DWD. It's my initial understanding that before going on the record for day 3, Attorney Hitchcock Cross began acting like an attorney about former Secretary Carr's involvement in the underlying case, to the point that Andrea ended up calling 911 to report Hitchcock Cross for acting like an attorney. I think that's a fair statement. I think
Well,
the
that's what
video
happened. That's
would bear that out. Yeah.
yeah, that's not what they wrote, but of course, yeah.
Okay. This is Matthew Foley. And to be clear, I've made several, if you don't recall, Matthew Foley, Andrew Olmanson sent me several threatening letters, I think 4 of them, threatening my career, my reputation, my family, um, all sorts of things.
Making
My client.
making she also makes a lot of insinuations or outright directly explicitly that you have, that you require some sort of intervention medically or something. And that is such a low bottom feeder kind of response to things that someone in her authority and position should know that, you don't weaponize your thoughts about somebody's medical anything. It's just a low blow to go after, even though it's false. Like who does that?
Well, I guess we know. So I made a complaint to Mr. Foley about his subordinate attorney's conduct in sending me those letters. And he responded to me that he has addressed the situation as he saw fit and nothing else. And you tell me if her behavior changed in any way. Because I didn't get that sense, but others may have. I talked to Michelle, who shared that Attorney Cross's behavior made them feel uncomfortable. I think that's probably true. I think me
Well, of
saying that they were
course.
acting unethical made them feel so I think that part's true. Now, was that disorderly? No.
Well, and also that we came with receipts. So yeah, when now you can't just ruin my character, you now have to respond to actual documentary evidence that directly links you to this behavior. So gosh darn it, I'm going to double down on the claims that you are
But
a
they didn't,
lunatic.
what they didn't know at this point that I had them all recorded. That's the beauty of a lot of these emails is they don't know. Pro
They don't
tip,
know.
pro tip number one, excuse me, Debbie. Did we get these emails from the Department of Corrections? No. And in fact, the Department of Corrections is going to tell us that they don't have any records, which is hilarious. We got these from the Department of Administration because pro tip number one, if you've got one government entity sending a communications to another government entity, you ask both government entities because you never know what you're going to
Mhm.
get. You
That's
never
right.
know what you're going to get. And you see here how it says at the bottom attorney client privilege communication. Now, it would have been attorney client privilege communications had Jared Hoy not sent this off to everybody and their mother. But as soon as he did that, then he knowingly waived his privilege because he's the client and he's the one who can waive it, and he waived it. And now we've got it. So I also submit that their attorney client privilege over not the whole case, of course, but over their advising on this issue here has been waived. But we'll get to that. I'm sure we're gonna have a lot of opportunities here. These guys, I get the sense that they don't know to the extent to which they violated people's rights and the extent to which they're basically, what's been happening heretofore is that they have been using their powers as quasi judicial entities to make everybody else run through hoops. But it seems like because of what they've done here, now they're going to have to run through some hoops to explain to some judges why that this behavior is okay.
And each of those tiny little cuts, like that attorney client privilege communication at the bottom, I would love to statistically see what the numbers show. Where do they slap that on every single email? Because we know that is something that they often claim that bars them from sharing things. When you look at who they're communicating with, there's no possibility for this type of attorney client privilege to exist in the government entity. So, like it's being revealed how each one of their steps on the ladder uh, are being cut out, and how each person played a role
God
in the
bless the
whole
in-person
chain.
hearing. That's what I got to say. Whew. Okay. Michelle said that the hearing is proceeding in a smaller room at several tables. I think that's incorrect. I think it's a bigger room at several tables, but whatever. One thing I want to say, when I listened to the last video that Debbie and I did like this, after she would talk and then I would start reading and I would say, okay. And I can tell you that every time I heard the lead attorney and AV do the same, have the same dynamic, and he would say, okay, I also hear the lawyer do the same thing with his dad, and it comes off as like, shut up, Debbie, I'm going to talk now. And I don't think that's what any of these people mean. That's certainly not what I mean. It's just my way of indicating that I'm moving forward here. And we all know that Debbie would interrupt me if she wanted to, but that's my mansplaining for all that.
We've seen it happen, actually.
All right. Um, Capitol Police showed up at Okay. Capitol Police showed up at DWD. Andrea made a statement, and Andrea, Michelle, and Steve, our paralegal, feel comfortable proceeding with the hearing. I think that's about as good as an admission as one could wish for, besides, of course, the videos.
Yes, after talking about it, we realized that we went overboard in our attempts to make Ben look like the bad guy. That's kind of there. Yeah.
on public
But we will
records,
continue to milk it.
I still don't have a public records response from the Department of Administration. The police, the Capitol Police, is run by the Department of Administration, and we'll get into that in a second. Because these guys are the Department of Administration. I had a very nice chat with the paralegal there, who informed me that she had done all the redactions for the police reports and all of these things, and that she had given them to their attorney. Used to be a paralegal, know how these things work. And so I emailed the attorney and said, "Hey, attorney, what's up with that?" She says, "Gosh darn it, Ben, you just want to control everything. And we got to take our time with these things." And they're like, what the law says, as soon as practicable. And gosh darn it, we're doing the best we can. Little do they
Right.
know that I've got this recording of the paralegal telling me that she did all the redactions, and it's been sitting on that person's desk for some time. I give her the paralegal credit for not giving the exact definition of what some time was, but I got the sense that it was some weeks.
And by
So,
the way, you're trying, and in the same sentence, they say you're trying to control the situation by just merely following procedure. Um,
well, and right, they
yeah.
cannot, two different kinds of public records violations. One is the denial of the records, the failure to produce them. The other is delay. So just like when Eric DeFort, who we're going to get into here, he tried to get us to pay Teresa Falaron to pay $1,000 for her own case file. That's
How ridiculous.
and then when it was pointed out to him, the Supreme Court, how it was in and the fact that he had it in electronic record, and the fact that he was participating in the denial, that is
Yeah.
a delay in and of itself. And the fact that I, as an attorney, had to spend my time and money making them produce the records, which they should have already produced, they need to pay for that. So that's the problem here. Is Eric DeFord, who's supposed to be a a neutral party in all this, actively put his fingers on the scales, and we'll get into maybe why the reason of that is, by demanding that we pay $900 for the case record, which he had
From,
an
yeah, from the
electronic
Equal
copy.
Rights
And
Division.
his
Yeah.
proposal was to hit print and then charge us $900 for that, which,
I have no words. It is, and we see this as a trend everywhere. It's been going on for years now. That if you can't deny a public records request any other way, and you've exhausted all of your other cards that you usually use to get these people to go away, hit them with a big fat egregious over the top bill, and then that'll at least buy you some more time,
but
and then hey, you get a couple bucks too.
that's the last refuge of the scoundrel, because that issue has been decided by our Wisconsin Supreme Court 10 years ago. And I
Right.
stopped having to tell people that you're not charging anybody. Look at Journal Sentinel versus who, I think it's whatever. Uh, Journal Sentinel, boom, records. Okay, so they
Yeah.
stopped doing that about 8 years ago. So
Yeah,
these
it's
guys
old
know
news.
this is old news. But for this ALJ, he thought he was being clever, didn't get the memo, and tried to pull a fast one. And now he's supposed
Yeah.
to be the judge in the case, and he's probably going to get sued because he owes my client attorney's fees for denying her public records request. That's a
Yeah.
problem.
No,
That's a problem.
nobody told them. P.S. We don't do that anymore. We in the era of technology, we've moved on to saying there's a technical glitch or
Well,
something like that.
and they didn't tell him to say, to not email the secretary about the public records request. They didn't tell him to not do that either. So he should not have been. I mean, well, we'll play the video too, and we'll get into that. Oh my gosh, maybe we'll get through this one. Of note, For the first day, the Capitol Police is now deciding whether they can spare an officer to remain at the hearing for the rest of the day. And I don't know if anybody else saw this, meaning I can't recall if I talked about this or not. We have an email from Michelle Zacard, Andrea Olmondson to Judge Benitez Morgan, and it's a motion. And there's 2 points on it, and one is they want a police officer there all the time. The other one is they want us to be separated when we get there at the beginning of the day. Now, the judge, and I think you were there, Debbie, the judge mentioned that. We talked about that. There's recording on the hearing all about that. She doesn't say that she emailed Matt White immediately and asked Matt White to arrange for police officers to be there. She doesn't say that.
No, she played dumb.
She played dumb, but
And
we have that email.
played dumb. And that really shoots her credibility, because instead of just owning up to the discussions that evolved around the decision making, she patronized us. And also, I mean, she's not a good actress. Like,
No,
you've got to come with good acting skills if you're going to try to pull these lies off to people that have two brain cells to rub together. We're
I
not
think
going to buy it.
I think it's fair to say that much of their frustration that day, those weeks, was born out of the fact that we didn't buy anything that they were selling. And we only pretended even for some moments, but at no point, I mean, you can just hear me going, uh-huh, uh-huh, uh-huh.
Well, no, we do what any citizen is starting to wake up to, which is you go along, you get along to go along, but then you go back and you pull up your receipts
Oh, I'm not
and you
saying we're not
come
being
back at
polite.
it for
I'm
the
s
15th time. Yeah.
We're just not buying it. All right.
Yeah.
Of note, for the first day of the hearing, Monday, apparently the ALJ had Capitol police officers present in person. Now, the problem is Benitez Morgan makes several conflicting statements about that, so that's hard to know. But that I think that was generally known at the in person at the hearing. However, that was only for the first day. Now, I know that now at this time on October 2nd, I didn't know anything about the first day. I said I don't know where the respondent got all this information from. You know, possibly from the government bureaucracy because they're all talking about it.
Yeah, the
But
telephone chain was
the,
already ringing off the hook.
you got it. So let's just keep going. Let's see what Secretary Hoy did. Remember, Secretary Hoy is literally the respondent. Okay, so let's
And
not
and
keep that in mind.
an active hearing is underway and they are clucking away like little schoolyard chickens.
It never
Yes.
happens, Debbie. This is not actually happening. This
No,
is
it
not
doesn't happen.
happening. Okay,
No.
I think that's important to keep in mind. All right, Mr. Jared Hoy on Wednesday, October 2nd at 11. We haven't even gone to lunch yet. And they're already interfering with the case to Paul Hammer. Now, what a cool name. Paul Hammer is the deputy secretary of the Department of Administration. So he is the direct boss of the new hearing examiner. And also Coinky Dinky has powers over the Capitol Police. It's
Mm.
just for fun. Now, then there's Mary Kay Sergo. That is Jared Hoy's deputy. And then now we finally understand how the governor's office and the Department of Justice became involved. Because remember, there's that video of the cop running around talking about, all these people are involved and calling him and whatever. So we've got Mary Kay, Catherine Domina is like one step away from Governor Tony Evers. And you may not know this, and I barely know this, but my sister, what the hell? I'm gonna toot my own horn. Is formerly the chief of staff for the governor of Pennsylvania. So whenever I want to know how the governor's office works, I go and ask her. And her information on that was that all secretaries have a um, person in the governor's office who has, and I'm trying to remember the right words. One is listening, and the other one that was one word. That means taking information from the DOC. And then there was another word which basically meant giving orders from the governor to the DOC, listening and something else, and roles. And
Yeah.
we'll leave that
Yeah.
off.
So
And that so the point is that this person is both the direct conduit from the respondent to the governor. Okay? That's why this administrative law system is completely broken, and we've got it right here. This is the respondent is not liking what's going on in the hearing, meaning that they're being called out for their potential ethics violations, and that they're going to the governor, who's the boss of the hearing examiner. It's literally, that's why we've called them from nearly day one since we figured this out, that the ALJs are not judges. They're not members of the judicial branch. They are attorneys working for the governor. And this is precisely why this is an issue. Now, and remember,
and it's
sorry, please.
it is the design of the system. So they have put in with the setup, they've always removed responsibility of the decision maker by sliding in either another title or another layer so that it can be, nobody's ever going to get a serious charge against them. Um, but like you said, that's why they're attorneys and not actual judges, because so many of these things they're not allowed in the purpose that they're serving anyways, but they would be out on their butt in a half a second with these behaviors.
Well,
They are
because
not
they would be unelected. That's the reason why. Because
right.
the judges are elected, and presumably the people of that county wouldn't put up with this garbage of them of basically the judge working behind the scenes with one of the parties. Because this is exactly what's going on here. And this is now the
This is
governor's office is
yes,
involved. Remember us, we're saying that we're getting intimidated by the police here. That's not by accident.
yeah,
No, so Secretary Hoy goes to, and then he also, the fact that he sends this to Paul Hammer this is precisely to get the police involved. This is what the request is. And that's when I confront Benitez Morgan about who's the one who's making the decision. The answer is it's Matt White and Paul Hammer. That's who it is. That's what the answer is. When she says she won't tell me because I'm being rude, I think the real answer is she won't tell me because the answer is inconvenient for their claim that the governor's office is not involved. So,
yeah.
FYI, Jared Hoy says to the governor and the chief of the police, FYI, several attorneys from our Office of Legal Counsel apparently ended up calling the Capitol Police on opposing counsel during an employment hearing. FYI. You know,
FYI,
when else do we get FYIs,
during
Deb? Yeah.
right and all the time during unemployment hearings. So I also want to point out that they knew and it was presented to them by their colleagues during unemployment hearing. Benitez Morgan later tried to claim that I turned off the recording because this wasn't during your oral argument. I just turned it off and we don't have it anymore. We don't have that piece of evidence anymore because I turned it off. Um, they know it happened during the hearing. And while you were making a legal oral motion or argument, and that's what set that other attorney off, was that you were willing to say the words that represented their behavior in a legal setting.
She
And
did
they never have had people willing to be able to do that. They
well
have
the
not have the strength to do that.
and I may be wrong. I've only watched it a couple 50 times, but it's my recollection that she doesn't hit the because you can hear her touch the call button, that she doesn't hit the call button until I raise the issue of ethics.
Right. And she also claims that it didn't happen during the hearing. Like that this police incident was separate from the hearing. And so she didn't want to give, she didn't want to be a witness. She's made a statement that she didn't hear or see anything to the police when she was sitting right there because it was during a hearing. So I guess I ask you this, if your hearings are running and you aren't paying attention or you aren't in the room or you aren't recording things, then you're not even good at the least part of your job, which is ensuring and maintaining an accurate record of an active hearing. Where
Oh,
were you?
oh, right, right. Well, remember it's possible that they were too busy keeping other people from recording to remember to hit the record button, or it's possible they lost it. For what reasons, we'll leave that up to you.
Technical glitches. They come in to save the day.
Technical glitches. All right. And again, what this FYI thing is just the grossest because you see that all the time for Maria
Yeah.
Celsor sends that to
Yes.
Natera or John Gelhard, for example, will send that to Celsor, and you'll get those emails. FYI, hey, just for your, I just like to keep you
FYI.
informed
Yeah.
about things. You don't
Here's a
participate in the
bunch of
decision, right?
Oh, and why don't they put attorney-client privilege on any of those? FYI, here's a whole bunch of private information about what's happening with an active case and opposing counsel, and anybody that might ever bump into this person in their career. FYI, pass her
FYI,
around.
you got it.
Yeah.
All right, Jared Hoy. And again, thanks for Jared Hoy for breaching your attorney-client privilege. Now, this is going to get interesting. Here's Paul Hammer before he drops the hammer down on Ben Hitchcock Cross. He's got a few questions, and you tell me why this is important. Thanks. A few questions. I assume Stolar is a DOC agency. No, wrong. It's a lady who got her boobs grabbed by DOC employees. That's what it is. Or I started to say allegedly had her boobs grabbed by DOC employees. We haven't had a fair hearing yet to determine whether or not that actually happened. Is Cross a private attorney or are they with a labor group? Question mark. Now that I could make that into its own video, I think, of why in the heck does the fact that I'm a private attorney gonna go to jail, straight to jail, or with a labor group, we're gonna give you a kit gloves. That's the impression I get. Why does that matter? I don't know.
Yeah, because your treatment is going to be different based on those filters,
Well, we
right?
right.
I mean,
We know that from MPS, right? If I'm with the MTEA, there's one kind of treatment, and if I'm with I mean, to put it another way, if I was with one of their pet unions, they would treat me as they would give me better treatment because I would be in theory working with them against the workers that I'm supposed to be helping. But if I'm private, then it's a different story.
if you're private, you're independent. And if you're hooked to one of these labor groups, there are several people they can contact to handle you in a scripted way. So that's what they're trying to decide. Is this person going to tell the truth because they're not allegiant to any of these other groups, i.e., private, independent, or are you with one of our puppets, team of puppets, and we can call the right people and they will know how to pull the strings?
Right. And so far we don't have anybody saying this is a active hearing that we're participating in. I mean, you can kind of read that from between the lines, and I mean, it's baffling to me that Hammer doesn't know, but we'll see what the answer is. Was the
Well,
AL I should
look
have said
at the time
okay.
of this too.
Yeah.
It could have literally just you were in the hearing while this was going on. Like this, there were proceedings happening while these people are discussing
This
these
is
things.
pretty close to when the hot mic is going on. This is like 30 minutes after the hot mic. So, yeah. Another one. If it wasn't for the hot mic, boy, would we be screwed. I'll tell you what. Or thank goodness we learned the truth. Um, well, because and what I'm saying there is, it's my belief and understanding that they were actively setting me up for consequences. And it was when they were chagrined, that when they were saddened by the fact that I wasn't arrested, when that was unfortunate to them, that was just only part one of their plan. There was more out there, and I think there still is more out there. But we'll see what
Oh
happens.
yes, yes, it's far from over.
Stolar is a former DOC employee. You see, he lets the cat out of the bag. Hey, these are attorneys, and we're working for the governor too.
Yeah,
Ben
you
Cross is a private attorney, not associated with labor. Don't ever forget that.
blocked.
It is actually a DWD Equal Rights Division hearing, ALJ, that's been part of Cross's complaints. And this is, I give Hoy a lot of credit, or he lets the cat out of the bag, or I don't know how you want to put it, but here's the true statement right here. Because Amy Petchacek, the person who used to have my job, was department deputy secretary at the time. I guess Cross was screaming at the ALJ yesterday to the point that she needed to take a break to regain her composure. I hope that's true. Because if it's not, I hope it's true. Because if it's not, there could be a consequence. Just like there could be a consequence for a government official um, stating that I was yelling, for example.
Right. And they offer no proof of anything, and you actually have all of it to the contrary. So when are they going to stop pretending like they don't know what's going on?
There you go. Now, it's like each email, it's not just it's like all of their defenses. I mean, you could not ask for anything better than this one, are just crumbling, crumbling, crumbling. Thank you. Whoever at the Department of Administration sent this to us, thank you, and thank you. Because you
And
had
there
to know
was
the
somebody
consequences.
who did what they were supposed to do, which was enter in the keywords, enter in the stuff, and hand it over.
Now, once again, I have an email here. I think we can just show it right here. Let's see if this works. Bam. Do you see this? So
Yeah.
I that day, as soon as I got this, and of course, and this is pro tip, or I guess it's pro tip number one again. I sent an email to Mr. Jared Hoy directly because I had his email now. And I said, hey, Mr. Jared Hoy, I'm going to need you to give me all of your emails with these keywords that come from this document. And Mr. Jared Hoy fell into the trap there. This is why this is taking a few days. So, Public Records request of November 21st. Reference, yada, yada. Dear attorney Ben Hitchcock Rose, at least they get the BHC right. I'll give them credit for that. Kindly produce all public records in your custody for 2022 regarding the Stolar case. Kindly also produce all of your emails from 2022 with the keyword Stolar, Petchacek, and Adria. Pro tip number 2, let's spell the first names of people's right when we're putting them in the public records request so they don't just deny it on your bad spelling. Just, pro tips out there, okay?
Yeah, you got them that one. You gave them that one.
And I'm going to blame, is it Steve Jobs still? Do we still get to blame Steve Jobs?
Why not?
Right?
He's
I mean,
not going to say anything.
he's not going to say. I still blame Bill Gates for every time my computer crashes. So, what the heck? Um. Okay. So, not my fault. Everybody's fault but mine is what. Now we can move on from that. Um. The Wisconsin Department of Corrections has reviewed its files and has determined there are no responsive records to yours request. Shucks. Shucks.
Yeah.
Dang. And if you went to a judge with that, you'd be like, I think they do.
I just read some.
I think they do. Oh, I sent them the copy of the now that the cat's out of the bag. I sent them what we were looking at now and said,
What about these?
what about these, for example?
What
Hey,
about these?
what about these? And
Well,
yeah,
that's in a server that's across the county line.
oh yeah, we keep those in Illinois. Thank you, Tim Cook. Yeah, right. Okay. They're under EU jurisdiction. All right, here is, and we need to take a pause for a second. This is extremely serious here. This is basically, in my opinion, the death knell of administrative law here, and proves all of the people who have denied that the secretary's office does not get involved in specific cases or liars. Straight out, that's a lie to say that. Now, here, Brian. This is Brian Hayes. Guess who Brian Hayes is the boss of? That's Eric DeFort, the ALJ, over the Teresa Falleron case that the DWD just contracted with the Department of, not it will contract with the Department of Hearings and Appeals to hear the case. It's another
Yeah,
FYI.
only the secret secret discussions are happening at this point, but the contract will be executed shortly.
Pro tip number 3, European 3 here. FYI is a good keyword.
Ooh,
FYI is
that
a
is a
good
good
keyword.
tip.
All
Good
right.
tip.
Because all the smoking guns have the FYI in it so far.
Love it.
This is an FYI, but Pam, and now Pam, here's 2 things about Pam McGilvery. Pam McGilvery, 1, is the Deputy Secretary of the Department of Workforce Development. Number 2, she's about as connected to the Dane County, that's the Madison Employment Lawyers Group, as one could possibly be. The firm that she left, broke up, and some of them are with really noted noted employment law firms in Madison, and that whole there's a Madison group of attorneys in Wisconsin, there's a Milwaukee group of attorneys, and then there's the people that don't exist. And no, I'm only saying that because I learned that just being in Eau Claire. I heard that like 3 times in one day. It says people in Milwaukee think we don't exist. Smart
I
people
would
don't.
say that that's a very believable um, perception.
I was going to say that smart people don't comment all the time. But yeah, I understood that. So my point is that with all opportunities for growth, I think we need to understand that they do exist, and there's a lot of the state up there that needs to be looked at. And certainly, they have a contribution just as much as anybody else into the fact that this administrative law situation is broken.
And
Hi, Brian. This is an FYI, but Pam at DWD thought you should be made aware. Now, why is Brian Paul Hammer, the deputy administrator of the DOA and deputy secretary of the DOA and the deputy secretary of the DWD talking? And the outcome of their talk is that the new ALJ should be made aware of what's going on in active case. Somebody tell me that
right.
that's a broken system or not.
And this is the very that is, as you said it earlier, the nail in the coffin, because they take this bias and they push it into the current case and even call it out and
Right.
say,
Because
you should know this
even if
about
they
the
didn't put
person
it,
you're
sorry,
working
I'm
with
doing it.
right now.
Even if they didn't put it in the contract to bind this guy up, we're going to make sure that he's bound up and he knows that Ben is a jerk. That's the concept here. We can't take a
Right. Yeah.
chance. We can't have it come out, possibly, frankly. It's my opinion that the reason that the DWD has gone to such great lengths with Teresa Falderon's case is because it's desperate for Calvin Furman's not to have to testify.
It would be very horrible because his name is all over everything.
Well, and
And
everybody has recused themselves because there would be the appearance of bias if they were to rule on Calvin Furman and their colleagues. So now we can have Eric DeFort do it. No problem. Well, except for he might not know what he's supposed to do. That's the problem, right? So,
right.
and
And
this tells you, sorry, again, that obviously if they have to go tell Mr. DeFort, then obviously they're talking to their people all the whole time, even though they say they're not. Because why
yeah,
would
this
they have to
just
go tell Mr. DeFort? It's because he doesn't know what they've already told everybody else.
yes, and we're packing a really big snowball for you over here, that's ready to roll with a whole bunch of stuff anytime something falls apart. So if the contract, if you miss something in the contract that we've already bound you to, then we've got all this other stuff waiting in the wings that you can throw out, and we'll all back you on it.
Well, at this time, there's no contract. There's no mention of any contract. There's no decision. But yet, this guy, Pam, seems to know who is getting the case and thinks he should have
Right.
some information before he actually gets the case. And we got the video,
And
gosh.
everybody knows about it.
But when you watched the video of Mr. DeFort's pre-hearing conference, did he ever mention this conversation, Debbie?
He never did. And you directly asked him if he had any discussions about you and any of the historical pieces that have been in motion specifically about your representation. And he declared no, no, no over and over again. And not only did that, but attempted to, and the opposing counsel did the same thing, attempted to make it seem like you were some, conspiracy theorist of sorts by even suggesting such. And so that is going to, come to light again, even though we've always proven that time and time again. But at some point, somebody above them, it's going to get outside of their circle, and a decision maker is going to hold them accountable for those things.
Well, let's see.
It's
Let's
going
just
to get
see.
outside their circle.
My guess is that when Brian Hayes tells Mr. DeFort that he wants to, prejudice him about the case, that Mr. DeFort is going to say, no, I can't hear about that. That's ex parte. I don't want to have anything to do with it. What do you think, Debbie?
Hey, I would say, listen, this is actually a case that's, ongoing right now. And really, I'm not supposed to talk to anybody about these ongoing cases. Nothing you could provide me. You're not a party to the case. You're not a witness in the case. There's no reason why I would need to talk to you. So save it for, put it in a box and we'll reconnect in a year or two when all this is wrapped up. But I certainly don't want to put myself in a position where I'm getting information before I've even spoken to any of the parties. it, Anything you say doesn't seem remotely like it could be relevant at all to my work as a judge. I wouldn't need any information from you.
Well, but right.
You're my colleague. Yeah.
Thank you, Debbie, because they're sworn to only make a decision based on the evidence before them. But we'll
Right.
see what happens. Okay.
I
Brian Hayes sends it to Eric DeFort. And Eric DeFort says, thanks. Actually, there's another email where Brian Hayes says into him saying, we need to talk about this.
Yeah, this isn't the only stuff. And for Mr. DeFort, Judge DeFort, to simultaneously project
Oh,
that
he
you're doing
pretended.
something.
He pretended.
Yeah.
Yeah. I'm sorry, Debbie. I was there. I'm a little bit.
Well,
Yeah.
and just like any good judge would do, Judge DeFort, if you didn't recall if you had these discussions, so let's give you the benefit of the doubt. You're a busy guy. Maybe you didn't remember that you had these discussions, these specific discussions. And by the way, we're talking a matter of weeks here, not years and years. What do you advise witnesses to do? Say you don't remember, and as a judge, you could have went back and checked, but you didn't. You answered with a no,
You answered with the
which is
no.
not true.
No.
And you answered no with having this conversation in October, and your um, initial hearing, pre-trial hearing, was just a few weeks later. So even if you had such a faulty memory that you couldn't remember this string of emails about an active case coming your way, which is an outlier case from the DWD ERD, it's not even, in the masses.
Oh,
it's
it's
an
never happened
outlier
before.
case.
They don't even know how to set up the file system.
Right, you can't even, right, they're using people's Google Drives for the official record. Come on. Some of us are beyond this, and you're going to need to either start telling the truth or get more tech savvy, because this simply doesn't hold water.
Or yeah, well,
And
instead of
so
lying to us better, maybe they could find employment elsewhere.
I would never suggest that they lie better. I would hope that they could just stop lying as well. But that doesn't seem to be in their queue at all. It doesn't seem to be amongst their decision options. They just default to overlaying some garbage.
And as we saw with the last video, the fix is already in with the contract. And as we'll have to show with Mr. DeFort here, he doesn't say anything. You will know, of course, that we filed many things with Mr. DeFort. Now, the judge before that said you got to put a fancy caption on things. And so Mr. DeFord is playing the same game here where he's not responding to my emails about this. The problem is that he's a lawyer. And it's been brought to his attention that he wasn't candid. And he needs to correct that situation. And that's the bottom line here is when you look at the video and what he told us that he doesn't even say, he says the only information I have from them is this agreement. He does not even say, to my recollection, whether or not that he believes that that agreement is binding and that it's a contract that bakes everything else in. I had to. How did I get that? I got that because I demanded it, and because we did public records requests, and they knew they had to give it to us. And that
And if
document
these,
showed it was a contract, and that he doesn't have a choice.
it was a contract in which they dictated using the language, this is law. Okay, they're not lawmakers, by the way, but they tempted to claim that something was law, previous motions, and then they signed it. And so, like all good judges would tell any witness that sat in their chair, if you signed a contract and you didn't read it, even on your worst day, if I believe that you didn't know what was in that contract, in your role, you should never sign a contract that you haven't read. And so, first of all, I'm not even going to believe that someone of your caliber would not glance at the specifications of a contract
Mr.
of this
DeFord is not a
magnitude.
stupid person. He's not. I mean, you can
I
see that
know,
in the
I'm
video.
just saying that's why it's so stupid.
It's so stupid that they're
That's
playing
what
these
I
kindergarten
mean.
games. Yeah, here we are.
It's
So
like, come on. But the funny part is I'm just doing a little bit of lecturing that they typically do to people that they downgrade in their mind. What did Ann Molitor say? These are not savvy folks, or they're it was an even more offensive word than that. Sophisticated. The people that come to me are not sophisticated. That's what she wrote in an email. So these judges think that none of us are sophisticated, and we could never understand the intricacies of their work and their decision making. Well, I have news for you. We do understand it, and we don't think you're doing a good job.
well, look, 1976, they created these rules and they said specifically you can't have these kind of conversations. And so what the response is, instead of not having their conversations, they rely on this judicial a presumption of non-bias for a judge. And then they sit there and they hide this and they're daring us to sue them, which is what we're going to have to do. Because this, right? I mean, if you tell me what is a bigger smoking gun for Bonita, I mean, how are we supposed to continue to have either a Stolar hearing with these people or a follow-on hearing with these people? They've completely corrupted both ends of it.
They have no issue misrepresenting and distorting every single transaction, even the stupid ones that are not, they're low risk, they're not worth, everything has to be dictated by them. And there's just no way that certain people can go into that setting and expect that they are going to have any ounce of impartiality that could put, it just doesn't exist.
It doesn't exist.
Who would expose themselves to that? I mean, just waterboard me instead. You know, um, Not going to happen.
Right. Well, Mr. DeFort should be ashamed of himself. Mr. Hayes should be ashamed of himself. Mr. Hammer should be ashamed of himself. Mr. Hoy should be ashamed of himself. Um, Mr. Foley should be ashamed of himself. And of course, even it's the one thing I will say is this: it's not obvious to me that Andrea Olmanson and Michelle Zacard have specific knowledge that this stuff is going on behind the scenes. My guess is that they're living in a world in which they just happen, these things magically just sort of go their way, and they think that they're doing good. But if we find the
Um,
evidence that they're participating, yeah, I know.
was in the room. There's only a certain number of people that were in the room.
Well, it all comes from
I
Andrea and
know
Michelle.
who
There's
the,
no doubt about that. It's
that's what I'm saying. So, Ben, besides me and you and Mike, and then the judge and their paralegal and the two attorneys and the police officer, it's one of those people. And so we know exactly where it's coming from.
oh, I suppose that Michelle and Andrea said they went to their boss and assumed that the rest of this was going to happen. I'm just saying we don't know that.
Unless they have a recording device that's live streaming to somebody sitting there.
Yeah, all right.
It,
Fair
maybe it's
enough.
one of those secret buttons.
Fair enough. Oh, we now learn that the secret button is called the distress button, and that the judge duress button, and that the judge knew all about it, and that they were actively trying to move it around on the room even up until Wednesday, I think.
And
So
it's portable, gosh darn it.
it's
So, you know
portable.
what? If it's portable, could you move that duress button into a bigger room, please? At least so that we don't have to sit 3 inches from a person who's, doesn't want to see our face. Put a little space between it.
We'll get into Rusty, I think, soon enough. All right,
I'll help them move the table.
fair enough. All right. Thanks for sticking
Okay.
with us. We'll keep you informed.